Yo, folks! It is Thursday, and today we are going to Canton, Massachusetts for a bit of update regarding the civil cases, or in this case, let's see here, Sarah. It's well, regardless, this is from Timothy Bradle. We are, Timothy Bray. Oh, I had the wrong person on the thumbnail. Oh well. So a bit of updates out of Canton. We have Aidan Kearney, who is currently he is fighting on several fronts. He's been fighting criminal charge since forever, and the civil suits also as well. And one of the things that is in contention is his phone. They really, really want his phone. They really, really want to see what's in his phone. Here's the thing with reporters and journalists, regardless if they are independent or contracted by legacy media, the phones are probably filled with information about sources, information of contacts between people who has nothing to do with this current situation. Problem is that Commonwealth have historically had not that big of a protection for members of the press who operates under the freedom of the press. But last couple of years, it has been in huge demand, so to speak, for the legislators to do something about it. So now, finally, they are working through the process of getting a reporter's shield law in place in Massachusetts. So this is what we're going to talk about today. The Commonwealth versus Aidan Kearney and his phones, or phone. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Oh, raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
Yeah, hello everybody. Hello to my first and best moderator. Hello Gigi. Hello to Swamper, Jedi Jen. Everything's new over here. Mama Bug. Gwendolyn. Hey Gwendolyn. Becky. Let's see here. Taillight Fairy. Hello. And a whole bunch of you. A whole bunch of you. Thank you for being here. Me and Mr. Jingles, as you see, as he's only paw. Mr. Jingles really, really likes his strawberry hut. He really, really does. All right, let's get into, because there's another very, very recent update that we're going through after this, and this is Cambridge response to the court order regarding motion to compel the MSP to produce documents pursuant to non-party subpoena. So that we are going to go through after this. But here we are. We are here for Aidan. Dun dun da. Hold on. There. Commonwealth versus Aidan Kearney. This case is assigned to Judge Belezos. Sorry for butchering the name. Defendant Aidan Kearney's motion to stay further review by the Tain team pending imminent enactment of the Massachusetts Journalist Shield Law, which would prohibit such a search. Now, for obvious reasons, the Commonwealth thinks this is a reason to speed things up instead of, oh, new law incoming. Because if the new law gets a set date within a near future, what they want becomes not possible unless they really go through the hoops. And even if they have had access, then they have to destroy it. Problem here is, of course, we are talking about the Norfolk County DA's office and the Tain team, which has, among other things, apparently police officers? I don't know. It is, the Tain team has people in it who shouldn't be having this information. This is a case of, if they get to go through Aidan's phone and then they are told, no, you have to destroy and forget everything. You can't put the toothpaste back into the tube. You can't put the shit back into the horse. You can't unfuck a cluster F. That's the problem. Now comes the defendant, Aidan Kearney, by and through counsel, and respectfully moves for a protective order pursuant to Mass Crim, that rule, and the inherent authority of the court staying any further review, examination, segregation, or dissemination of materials seized from Mr. Kearney by any government quote-unquote Tain team. As grounds, a bill shielding such searches, Amendment 17, is footnote 1, is before the Joint Legislative Conference Committee with passage imminent. Massachusetts Senate 40-0 to adopt Amendment 17 Shield Law. Into proposed bill 34-6 to pass bill July 30th, 2026. An act promoting transparency and public access 125-28 vote. Bill presently in Senate House Conference Committee. Senate unanimously passes amendment to protect journalist sources. August 1st, 2026. See also Massachusetts Constitution, Part 2, Chapter 1, Article 2, pertaining to the legislators' 2/3 majority shall override governor's veto. There is no public indication found from the governor's office that she would intend to veto such a bill that reaches her desk. Yeah. So, by all accounts, this bill will go through. And quite soon. The Massachusetts Journalist Shield legislation, passed in veto-pro fashion, unanimously by the Massachusetts Senate with the cognate government transparency provision, passed previously by the Massachusetts House, is presently in joint conference committee. In further support thereof, defendant states as follows. Mr. Kearney's investigative... Is this the right page? Yes, it is. Mr. Kearney's investigative reporting and advocacy journalism is at the heart of the charges presently brought against him. In furtherance of the charges, the MSP arrested Mr. Kearney at his child's bus stop, entered his home and seized the tools of his trade, cell phones, laptops, and iPads. They now seek to search these devices and root through years of confidential sources. His case and these intrusions present issues at the intersection of the First Amendment, attorney-client privilege, and the sacred confidential relationship between journalists and their sources. And they have a motion to suppress for comprehensive background. I think we went through that a few months ago. If we did, it is in the Aidan Kearney playlist. The material seized from Mr. Kearney indisputably contained journalistic work product, source communications, unpublished investigative materials, editorial files, and confidential communications gathered during investigative reporting. See attached affidavit of counsel. Once those materials are reviewed by government personnel, the invasion of the journalist-source relationship cannot be undone. The court appointed a taint team to review Mr. Kearney's electronic devices and segregate attorney-client privileged materials. The devices contain attorney-client materials that predate this case on other matters and involve other attorneys aside from undersigned counsels. The court did not protect or address confidential journalist sources, leaving them fair game for review by police. Yeah, remember, folks, Aidan Kearney started investigating this, the Karen Read case, started reporting after a police source asked him to. There are probably more police sources in that material, and in Norfolk County, including Canton and Stoughton, we know what the cops do there. And it's just the fact that somebody dared to go against their local police. Not good. Not good. Presently before the court is the Commonwealth's request for carte blanche assistance from the police to allow the taint team to crack Mr. Kearney's devices to the fullest possible extent, many of which will only contain source material that predates the facts underlying the present charges. So yeah, the DA's office, the Commonwealth, is, yeah, we want the police to help us. And who might that be? Well, the Massachusetts State Police, or the members of the members of DA Morrissey's private police precinct, or whatever they call it. Let's see here. Where were we? The request contravenes Judge Krupp's December 27th, 2024 order prohibiting contact between police and taint team members. The Commonwealth is attempting to engineer the search for maximum possible intrusion just before the legislature slams the door shut. These sources are at imminent risk of exposure in direct contravention of this pending legislation and through means prohibited by Judge Krupp. Further, the defense specifically requested consideration of journalistic source material for inclusion in the taint team protections. With District Court taint team motion attached with affidavit of Aidan Kearney as exhibit, attesting to presence of journalist source materials in devices. Commonwealth's opposition is this is strange. Well, okay. Commonwealth opposition is document 74, which will be completely contravened by journalist shield law. The defendant's motion to include journalist source materials under taint team protection was denied via docket ruling by Judge Doolin. Obviously, there are changed circumstances. The legislator's recent action reflects a strong public policy determination that journalists should not be compelled to disclose unpublished materials or confidential source information except under extraordinarily limited circumstances. This search would be illegal under the Journalist Shield Law. Under Amendment 17, the party seeking such confidential source identity or information must establish by clear and convincing evidence that such identity or information is 1. Material and relevant, 2. Critical or necessary to the maintenance of a party's claim, defense, or proof of an issue, highly material thereto, 3. Not obtainable from any alternative source, and 4. There is an overriding public interest in the disclosure. Yeah, this is the same justice system that keeps protecting Michael fucking Proctor. But getting everything from a journalist, yeah. Accordingly, the importance of protecting a journalist's confidential sources, the legislators clearly expressed veto-proof intentions, and due process fundamental fairness considerations strongly favor preserving the status quo until those protections can be fully submitted through the democratic process. If review by the team continues before the court evaluates the pending journalist shield protection, the First Amendment rights issue could effectively become meaningless. Unlike ordinary discovery disputes, the disclosure of confidential source information cannot later be undone. Once government personnel know the identity of confidential sources, review unpublished reporting, or examine investigative files, the confidentiality the legislators sought to protect has already been destroyed. Accordingly, maintaining the status quo is the only remedy capable of preserving this court's ability to meaningfully apply the forthcoming protections. Granting a temporary stay causes little or no prejudice to the Commonwealth. The seized materials are already secured. No evidence will be lost. Conversely, denial of a stay risks permanent destruction of statutory and constitutional protections designed to protect investigators' journalism and confidential sources. The balance of harms overwhelmingly favors preserving the materials until the court determines whether new law will shortly govern this case. There is also a substantial public interest in protecting investigative journalism and preserving the free flow of confidential information concerning matters of public corruption and concern. The legislator's imminent adoption and passage of comprehensive journalist shield protections reflects a clear determination that these interests warrant heightened legal protection. Maintaining the status quo while the court evaluates the scope of these protections advances, not hinders the public interest. Hey, KCC Aid Kitten, thank you so much for your 10 euros. Thank you so much. Thank you. What charges is the motions for? Well, these are the criminal charges against Aidan Kearney. That much we can conclude through this motion. Don't we have a doesn't Aidan have a hearing coming up? Yeah, I think he has. When it's let me check. Well, you have the tentative trial date. December 1st. Yeah, I think today was a deposition. Was today a deposition? Yeah, today. He had the 2 dates to choose from, August 17th or August 20th, if I remember correctly. So, yeah, this morning. Yeah. Thank you, Corn Dad. Thank you. Yeah. Yes, drop today. TB pleads 5th. Yeah, as he said, because he is currently under criminal investigation. So this is just a tactic from the other side, which we can be sure will be leaked, even though the judge in the civil cases said those are not to be published. So we can almost be sure it will be published by somebody, sadly. For all the foregoing reasons, defendant respectfully requests that his honorable court stay or review, examination, segregation, indexing, copying, dissemination, or analysis of all of the seized materials by any government-tained team or filter team. Prohibit any additional review of the seized journalistic materials pending further order of the court. Preserve all seized materials in their current condition without further examination. Schedule a status conference in approximately 45 to 60 days to assess the status of implementation of the Massachusetts Journalist Shield legislation so that the parties may address its applicability to the seized materials and grant such further relief as justice required. Respectfully submitted, Aidan Kearney via Tim Bradle. Sorry for it. I need to change the thumbnail. Every time I see Aidan, he's having emotion. Yeah. So basically, this new shield law has passed the chambers in order to get it into law. It might have one stop before it's signed by the governor. We are talking about maybe weeks before the governor signs this into law. And of course, DA Morris's office doesn't care. They want this cracked open. And only shows that they really are, at this point in time, in my opinion, regarding the criminal case against Aidan Kearney, it is not for the Commonwealth about finding justice or finding truth. It is to punish Aidan for exposing corruption and a second-hand collateral damage. Find out who their sources are. And that's not okay, folks. That is not okay. It is sad that everything surrounding Karen Reed and Aidan Kearney and these cases is probably the catalyst that made the legislature go into overdrive to get this shield law into place. It should have been done a long time ago. But Massachusetts, for some reason, the freedom of the press doctrine for them has been a slight obstacle up until now. No politics, please. Even though I kind of agree. I will. Here's the thing about the DA's office election upcoming. I'm not from Massachusetts. I'm not even out of the United States. Don't allow the corrupt elements in Norfolk use me as a outside interference stuff. That is why you don't see me doing videos about the primary election for DA's office, because I don't want to give that ammunition in the hands of the opposition. So yeah, hopefully within weeks we find out about the governor signing this into law, stopping the Commonwealth to break into Aidan Kearney's phone. That is what we hope for. Right. Now let's see here. Because the next motion is also not very long, but also quite important. Hold on while I get it up here. Do not clip that. All right, so the next item is... Oh, I need to swoop. Here. Yay! That is the Norwegian fire-farting dragon. You cannot sneak up on that from behind. You will get injured. All right. Yeah. This is next subject is a motion to compel to the MSP. Dun dun dun. At the stage. There it is. All right. Commonwealth of Massachusetts Superior Court document. The O'Keefe versus all of them. Civil action number 2483 CV00692. Defendant Karen Reed's response to August 6, 2026 court order regarding motion to compel the Massachusetts State Police to produce documents pursuant to non-party subpoena. Defendant Karen Reed respectfully responds to the court's August 6, 2026 order directing her to address the MSP argument that she has not explained her substantial need for the documents MSP withheld as attorney work product, which are listed on MSP privilege log. Yeah, folks. First of all, the MSP took forever to even produce their privilege log. And the privilege log is the parties, this non-party, the Massachusetts State Police, even though they claim there's privilege, they still have to supply a privilege log, which is more or less headlines. This is why you can't have this. The headline, short description. This is why you can't have this. And they have asserted a bunch of it as attorney work product. And when it comes to a government entity who holds all the power to also have privilege logs, yeah, I understand if it is some individuals. But when it is about cops who has been fired and they assert privilege over the reasons why they are fired, fuck off. Seriously. But let's go through this. I am sure Karen's team will tell us why the MSP are being ridiculous. Oh, we have a footnote. MSP previously stated that it only withheld documents pursuant to the work product doctrine. Now its privilege log indicates that a handful of communications are also subject to the attorney-client privilege. MSP has waived any claim of privilege by failing to assert it, and affirmatively stating that it only withheld alleged work product. But even if it had not, MSP has failed to establish, as is its burden, that any of the attorneys listed on such communications were representing MSP or any of MSP's employees or troopers in connection with the subject matter being discussed. There is no general attorney-client relationship between MSP and prosecutors who represent the Commonwealth and not MSP. Therefore, the court should not consider MSP unsupported and very late attorney-client privilege assertions. By this, we can determine that these are communications between the DA's office and Massachusetts State Police. And that's, seriously, they claim that is attorney-client privilege. No, fucker. The DA's office do not represent individuals. It is in... Okay, but again, shows you why and how far they are prepared to go to keep their corruption a secret. As explained in Reed's prior filings in support of a motion to compel, Reed knows very little about the communications in question because MSP has not explained why they are allegedly protected beyond generalities and has not met its burden of establishing that they are in fact protected. However, to the extent the documents and communications in question relate to MSP's investigation into John O'Keefe's death, which they all presumably do, they are highly relevant to Reed's defense of plaintiffs' emotional distress claims, and she needs them to adequately defend herself. According to the SGC, a substantial need exists where the fact information is relevant and the requesting party cannot reasonably obtain the information or its substantial equivalent elsewhere. See all these cases. There also must be special circumstances excusing the movement's failure to obtain the requested materials itself. When interpreting the be careful with pronunciation. Analogous federal rule, courts consider, among other factors, the importance of the materials to the party seeking them for case preparation. 2, the difficulty the party will have obtaining them by any other means. And 3, the likelihood that a party, even if he obtains the information by independent means, will not have the substantial equivalent of the documents he seeks. And the case law for that. Ultimately, the substantial need inquiry requires a careful examination on whether non-disclosure will impair the truth-seeking function of discovery. And it's the Boehringer case. And also the Attorney General versus Facebook from 2021. The communications identified on MSP's privilege log are relevant to this case, in which plaintiffs have alleged more than wrongful death. Indeed, in their complaint, plaintiffs based their emotional distress claims on the premise that Reed created a false narrative concerning the cause of Mr. O'Keefe's death, which caused compensable harm to the O'Keefe family. folks, if there is information between the DA's office and Massachusetts State Police that shows that their case was weak, that shows they knew about for instance, the physics problem that the state has to claim, that the laws of physics do not apply to 34 Fairview. If those materials shows that the state knew their case was bullshit, but they kept going, then that is a huge piece of information for Karen Read to defend herself in this civil action. So, of course, the MSP clearly don't want Karen Read to have this weapon. Plaintiff have described Read's alleged false narrative. Before I forget, this false narrative. Now, the false narrative is the state's discovery to the defense. Remember, Karen Read, before this became highly publicized via Aidan Kearney, there was not much information out there. Not until Aidan Kearney started digging around and find all the fuckery surrounding the friendships between the McCabe's, the Alberts, Proctor, and others. They found that Aidan found that out via reading court documents, mainly. Also, apparently, information from Karen Read. But there's no law against a defendant talking to a journalist, so fuck off with that bullshit. And if the MSP is now trying to hide that they knew there were alternative suspects, because remember, folks, through the coverage of the Sandra Birchmore case, we now know that the feds were in Norfolk County at least a year before John O'Keefe was killed. At least a year. Through the Sandra Birchmore case, we know that the feds were involved already when Sandra Birchmore's autopsy was going on, which was almost a year before John O'Keefe was killed. The feds were already there. And the feds obviously got themselves involved in the John O'Keefe case. So, in here, in the MSP material, there may or may not be information between the Commonwealth and the cops that they knew they were under investigation. They knew the feds regarded the House defendants as suspect. Well, I'm sorry. The House defendants don't like being called the House defendants. I renamed them. We are now calling them the wankers. So yeah. But they are trying to avoid it. The things that aren't already destroyed, because I do believe that the corruption is so deep that they have tried to destroy as much as humanly possible. But there are still some information left between, for example, emails and stuff between the Commonwealth, the DA Morrissey office, and Massachusetts State Police. And now they are desperate in trying to hide that as well. Let's continue. As the court is aware, the false narrative and conspiracy theory that plaintiffs refer to is, among other things, Reed's claim asserted in a criminal defense, as well as other pending civil litigation in federal court, Bristol Superior Court, and this court, that MSP and his trooper conducted a biased, corrupt, and woefully insufficient investigation into Mr. O'Keefe's death and framed Reed for murder. Communications between MSP troopers and employees and the Norfolk District Attorney's Office, which was prosecuting Reed, are very likely relevant to these allegations. Obviously, if Reed proves what she has alleged, then she cannot be liable for concocting a false narrative or conspiracy theory, as the plaintiffs allege. And she would be significantly prejudiced if denied these documents. MSP's privilege log also makes plain that Reed has no other way of obtaining these potentially high relevant documents other than from the MSP. Yeah. She can't get that information through, because she can't depose Morrissey. She can't depose, Brennan. She has to have the documents. There is no other way. These are bilateral communications that can only be produced by the MSP or the Norfolk District Attorney's Office. The Norfolk District Attorney's Office asserted an objection to producing the documents when it received a subpoena. MSP did not. Therefore, MSP is the only available source, and Reed cannot compile the information herself or obtain it elsewhere. This is an even greater need than the SGC held was sufficiently substantial for work product purposes in Facebook Inc., where the Attorney General would have faced a heavy burden, but could technically have compiled the relevant information herself. Thus, to the extent the communications are relevant, and they very likely are, Reed has a significant and substantial need to obtain them from MSP. For these reasons, and the others explained in Reed's prior filings in support of her motion to compel, Reed respectfully requests that the court order MSP to produce the communications contained in MSP's privilege log. Yeah, and as we read, the MSP have to show that prejudice substantially outweighs the probative value. And again, Brennan didn't represent Proctor. Brennan didn't represent Buchanan. He was hired to prosecute. Michael Morrissey does not represent Buchanan, Proctor, Tully, Guarino, and the others. He doesn't. He's there elected to represent the people. Well, we now know that he only represents himself and his own personal needs. But by law, not a single person, not a single district attorney, assistant district attorney, actually represents the police, or individual police officers. None of them. None of them. Oh. All right, should we go through one more? Hold on while I download it. We could have some fun with the House defendants. I have here the plaintiff's opposition to defendant Kearney's motion for protective order. Yeah, it's a Can Read phones. It's the Can Read. When is this from? Oh, this is from July 30th. I think I might have maybe not gone through it, but referenced it. Let me see if I can find something. But now, you know what? We can actually go through that one. We can. Yeah, the prosecutors did nothing but defend the wankers and police in both cases. I completely agree. We need a swoop. We need another swoop. Yeah, again, that is the Norwegian fire-farting dragon. Can't sneak up on that from behind. All right, let's see here. Make it a little bit bigger. All right. Commonwealth of Massachusetts, Jan McCabe, Brian Albert, Colin Albert, and Brian Higgins, collectively known as the Wankers. Plaintiffs versus Karen Reed and Aidan Kearney. Plaintiff's opposition to defendant Karen Reed's motion for protective order. Plaintiffs Jan, Brian, Colin, and Brian, collectively the Wankers, respectfully oppose defendant Karen Reed's motion for protective order requiring plaintiffs to delete data. Oh, this is the one. Delete data incorrectly produced by the Norfolk District Attorney's Office. Yeah. Oh no, the Norfolk District Attorney's Office, by mistake, sent over unredacted documents to the Wankers. By mistake, they claim. Anyone believes this? That they did this? Mistake? No. Not a chance in effing hell that this was done by mistake. Now, Karen Reed has to ask the court to tell the Wankers, yeah, you can't have it, delete it. And of course, they oppose it. Let's see here. First, they claim the motion is procedurally improper. Discovery in this case was automatically stayed on July 7th, 2026, following Reed's filing of a motion to dismiss under the Massachusetts anti-SLAPP statute, which has now been denied, which is also under appeal. The relief Reed seeks is essentially an order compelling plaintiffs to delete certain data obtained through a subpoena issued during discovery. Yeah, hey, Wankers, you were supposed to only have the redacted version, not the unredacted version. So, no, this is not procedurally improper because you received the wrong material. Now, you may have heard this from other attorneys, US-based attorneys, that sometimes by mistake, that they CC in opposing party. Then you just contact opposing party A, don't open this, it was sent by mistake, you're not supposed to have it. And the other side, if morally having a moral compass, an ethical compass, they say, yeah, of course, we'll delete it. Not these fuckers. Not these Wankers. They really want to keep it. That is a discovery-related order. Again, you were not supposed to have the unredacted version. And the court cannot adjudicate such relief while in the statutory stay is in effect. Yes, they can, because as you yourself pointed out, this here relates to an issue that was before the stay. So the ruling in this relates to an issue that predates the stay. So no, it is not procedurally improper. No. No. Let's continue. Second, the data issue was lawfully obtained by plaintiffs pursuant to a validly issued subpoena served on the NDAO. Again, you were only supposed to have the redacted version. Reed failed to object or to move to quash that subpoena before production occurred and has not cited any authority justifying her request to claw back materials that were obtained through an otherwise valid subpoena. Fuckers or wankers, the reason why at least in my interpretation, the reason that it wasn't objected to was that the material was always supposed to be redacted. Always supposed to be redacted as discovery material. Hence, there was no need for an objection for that specific subpoena. You're welcome to disagree with me or correct me if you think I'm wrong. I don't mind being corrected. I don't mind being told I'm wrong, as long as it is constructive. Moreover, contrary to the implication made in Reed's motion, plaintiffs are under no obligation to honor the terms of a private agreement between Reed and the plaintiffs in an entirely separate case. Finally, the relief sought is fundamentally inequitable. Reed currently possesses a full phone extraction belonging to plaintiff Jennifer McCabe. An extraction McCabe voluntarily provided upon request. So, okay, we can now determine that the wankers don't know the difference between voluntarily and subpoenaed. Reed never voluntarily handed over anything. She was under criminal investigation, and they took her phone. Exclusively for use in the criminal case against Reed. Reed, however, intends to use McCabe's phone extraction, which contains years of information and data prior to January 29th, 2022, in their pending civil litigations. Oh, really? Do you know what you do then? You file a motion to suppress. Just as, for fuck's sake. For fuck's sake. In other words, Reed demands that plaintiffs delete her own phone data, but has refused to delete the identical category of data she holds belonging to McCabe. Then file a fucking motion and let the court decide. Reed's hypocrisy constitutes inequitable conduct warranting denial of the motion, or in the alternative, an order that Reed also deletes McCabe's phone extraction. Fucker, this is not a plus-minus game. If we can't have that, she can't have that, then file it. If you don't want Reed to use it, file it. File it. Yeah, as Klumper says, this is a ruse to get Yellow McCabe's extraction eliminated. They recover deleted text. Yeah. Yeah. As Mark Gillis says, this is not a tit-for-tat event. If you want that, because there are, as I said, these are completely different circumstances. Jan McCabe voluntarily handed it over. Her stupidity is on her. Karen Reed did not hand over anything voluntarily. She had to. That's the difference. And it's extremely, for me at least, disturbing that the House defendants don't know the difference between voluntarily and by force. Because if you don't know the difference between those two, voluntarily and by force, in what other situations don't you know the difference between voluntarily and by force? Think about that for a second, folks. If they don't know the difference between voluntary or by force in this situation, what other situations don't the wankers know the difference? Argument. The motion is procedurally improper because the automatic discovery stay bars the relief sought. Bullshit. Again, we went through this, but let's read it. On July 7th, 2026, Reed filed a motion to dismiss this action pursuant to the anti-SLAPP statute. Under the statute, all discovery proceedings shall be stayed upon the filing of a special motion to dismiss pending the court's resolution of the special motion. Reed's motion filed after the automatic stay went into effect asked this court to enter an order compelling plaintiffs to delete data they obtained through lawful discovery. Again, the underlying fact here is you obtained an unredacted version, which you should never have had. That's the underlying issue. And the underlying issue predates the stay. You should not have had it. You're not allowed to have it. The emergency in this overrides the general stay. In my opinion. Disagree with me if you want, but in my opinion, since the decision was regarding handing over the redacted version, and they was given the unredacted version, that overrides the general stay. Because they shouldn't have it. The prejudice against Karen Reed massively outweighs the probative value. It could also be an argument that the Norfolk DA's office did this with malice. Such a request at its core is one seeking to adjudicate the parties' respective discovery rights and obligations? No. Said otherwise, Reed is asking the court to determine what materials plaintiffs may retain and use in this litigation. No, the court determines that, and the court had determined that extraction, Karen Reed extraction, cannot be released unredacted. The purpose of the statutory stay is to protect defendants from the burdens of discovery, while the threshold question is whether the case is subject to dismissal under the anti-SLAPP statute is resolved. Allowing Reed to obtain affirmative relief relating to discovery materials while simultaneously invoking the state's protection against discovery in other aspects of this case would create an inequitable one-way ratchet that the legislators did not intend when it enacted the anti-SLAPP statute. Did the legislator foresee that the Norfolk District Attorney's Office are as rotten No, there's no way, because the legislators have to assume that the laws will be followed. Here, Norfolk District Attorney's Office did not follow the law, did not follow the court order, and handed over an unredacted version. It is not that hard. This overrides the anti-SLAPP stay, because the information they received, they shouldn't have had to begin with. Reed cannot both shield herself from certain discovery obligations and simultaneously wield a discovery-related motion as a sword against plaintiffs. No, this is not a sword and shield situation regarding discovery. You should never have had that unredacted version. No, so it's not a sword and shield situation. Because the decision was already made before handing over this, that the information can only be handed over as discovery redacted. Accordingly, the motion should be denied as procedurally improper or at minimum held in abeyance pending resolution of Reed's anti-slap motion to dismiss. Basically saying, we want to give us time so we can go through it all without permission. Reed's phone extraction was lawfully obtained pursuant to a valid subpoena, and Reed lacks a legal basis to compel its deletion. Yeah. Subpoena was valid. The information wasn't. That's the difference here. Yeah. You were allowed to subpoena the redacted version. You got the unredacted version. Wouldn't the redacted information be inadmissible? It would, but they are not supposed to have it at all. And through the redacted version, the redacted information, that wankers can use that against people outside of court. Further, the subpoena was validly issued, has nothing to do with it, and directed the NDAO to produce documents previously produced in the wrongful death case. The NDAO complied with the subpoena and produced the requested materials to plaintiffs. There are no allegations that the subpoena was defective, improperly served, or otherwise legally infirm. This has nothing to do with the subpoena. It has to do with what version did you receive. It has nothing to do with the validity of the subpoena. Reed also does not dispute that she was aware of the subpoena before the NDAO produced the materials. Doesn't fucking matter. Again, the subpoena here is irrelevant. It's the fact that they got an unredacted version. They got the wrong version. Under mass, blah, 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 a party affected by a subpoena must act with reasonable promptness to challenge it. She didn't need to challenge it because the assumption is that you would be given the redacted version. Reed failed to do so, instead seek post hoc relief regarding a subpoena that was issued over 2 months ago and a production that was transmitted over a month ago. Again, the subpoena in itself has nothing to do with it. Additionally, Reed's argument that plaintiffs should be compelled to follow the same protocol agreed upon by the plaintiffs in the wrongful death action is misguided. Plaintiffs in this case are not parties to the wrongful death case and were never part of any negotiation process or argument reached in that separate proceeding. No, you aren't. NDAO are. And that makes Karen Reed's request valid. NDAO promised Reed that this would only be produced redacted. Put simply, the agreement between Reed and the plaintiffs in the wrongful death case was a voluntary private agreement between different parties in a different case. Doesn't matter. Reed cannot unilaterally impose the terms of a separate agreement upon litigants who are not parties to that agreement and who owe her no contractual or fiduciary duty with respect to its terms. Take that up with the NDAO. That is your counterpart here. That is your actual counterpart here, in my opinion. This is particularly true where, as here, plaintiffs in this case are not similarly situated to the plaintiffs in the wrongful death case. Since Reed refuses to destroy the full phone extraction of plaintiff Jennifer McCabe, file a motion. Let the court decide. File a fucking motion. So, it's stupid. It's stupid. Oh, yeah, folks, by the way, if you didn't know, you might be new here. I have a few rules regarding trolling in the chat. B1, be funny. B2, be correct. Or 3, pay the troll toll. So, you have, if you are just here to be assholes, you can be. You can be correct. You can do it in a funny way. Or if you really want it in the chat, pay the troll toll. A super chat. If you don't, you will get timed out. Everybody know the toll tax, the toll toll? Huh? Now you're aware. So you have the... Now, you could troll the ever-living fuck out of this, but you have to pay for it. All right, let's continue. Yeah, Mark, I know sarcasm and humor sometimes doesn't translate in chat rooms. That is why I put it upon the trolls themselves to determine to raise the quality, or to be sure, yeah, I'm trolling, pay the troll toll. Oh, I'm about to sneeze. I'm sorry. Whew. Oh, I'm sorry. I did manage to mute it because I don't want to scream into the microphone. Yeah. First time, 5-minute rest, a 5-minute timeout. Then you know, okay, you're you're on. You're behaving. Be better. Be better. If you can't, pay the troll toll. Where were we? Refuses, blah, blah, blah. Of course, a voluntary courtesy extended by one litigant in one case does not ripen into a judicially enforceable obligation on an entirely different set of parties in a separate action. Now who's the hypocrite? Really? You acknowledge that voluntarily courtesy extended by one litigant? Well, Jennifer McCabe, in the criminal case, not the civil case, in the criminal case, voluntarily handed over her phone. Now, she had deleted a whole lot of shit in her phone. But she was found out. She was found out. So if Jan McCabe wants everything destroyed, go ahead. File a fucking motion. Read and identifies no rule of civil procedure, statute, or binding precedent that would compel the relief she seeks. Don't care. The relief sought is fundamentally inequitable. Even if Reed could overcome the procedural and substantive barriers identified above, her motion should be denied on equitable grounds. Reed seeks a court order, essentially compelling plaintiffs to delete data, yet she... Oh, for fuck's sake. Yet she refuses to reciprocate by deleting identical data belonging to one of the plaintiffs that Reed herself retains. This is not a tit-for-tat situation, asshole. Again, learn the difference between voluntariness and by force. There's a clear difference. Clear difference. If you want her to delete, file a fucking motion. J.K. Debug, didn't your ancestors give us trolls in folklore? Yeah, I mean, in Scandinavian folklore, we have trolls. And these trolls, that type of trolls are the physical embodiment of what is dangerous with nature. The trolls here are trollers. So it's a different type of trolls. Trollers comes from trolling. Trolling is fishing. Fishing. Dun, 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 dun. So they are fishing for engagement. They are fishing for reactions. They are fishing for emotions. So that's trolling, hence they are trolls. The Scandinavian or Northern Europe folklore regarding our troll, or the embodiment of what's dangerous with nature. If your child got lost in the woods, take him by the trolls. Stuff like that. So, welcome to history lesson. Blah, blah, blah. Indeed, plaintiffs could never agree to any proposal by Reed as long as she maintains inner custody and intends to use the virtually identical phone extraction of McCabe. Different apples and oranges. Voluntariness contra by force. It is undisputed that Reed currently possesses a full phone extraction belonging to plaintiff Jennifer McCabe, which Reed obtained during her separate criminal prosecution. Yeah. Yes, she did. Yes, she did. Because Jen McCabe handed it over thinking she had deleted all the evidence of her involvement in the murder of John O'Keefe. Doesn't trolls live under bridges? Yeah, among other things. Among other things. That extraction contains the same categories of personal information that Reed claims to be concerned about: private communications, medical information, financial data, geolocation records, and other sensitive material spanning years of McCabe's life. Yeah, but again, McCabe handed it over voluntarily, and the court there can say, yeah, you can't use that. Reed didn't hand over anything fucking voluntarily. Okay. Let's see here. First was 5 minutes, now it's 30 minutes timeout. Troll. If you want to troll, pay the troll. While Reed professes concern for her own privacy, she has made no offer to delete or return the analogous extraction of McCabe's phone that she holds. This is emotional blackmail that has no fucking place in a court filing. You fucking wanker. This is just pure stupidity. This is stupid to put emotional blackmail into a court filing. Seriously. Fucking seriously. This is bad lawyering. While Reed has stated that she will delete the extraction of McCabe's phone data obtained via the NDO subpoena in this case, she has explicitly refused to delete the McCabe extraction she retains from the criminal case. What? Notably, Reed obtained a copy of McCabe's phone extraction as part of a criminal case only after McCabe consented to its use by the Commonwealth as part of its prosecution of Reed. McCabe has never consented, nor does she now consent to that extraction's use in the pending civil actions for the same reasons Reed articulates in her motion with respect to her own extraction. For fuck's sake. Again, when Jen McCabe voluntarily allowed the Commonwealth to use Jen McCabe's phone in the criminal prosecution, everything in it became discoverable in the criminal prosecution. By handing it to the Commonwealth, she handed it to Karen Reed voluntarily. Her lawyer should have explained that. So this is no. This is a distinction without a difference. Fuck no. Fuck no. Hey, troll power. I hate trolls. Yeah, I do too. I think it's a waste of time, and the purpose of trolling is to waste people's time. Now, I do attempt to profit from it, because if you're here just to troll, you're welcome. You just have to pay. And thank you so much. Thank you. This here, where the claim is this is a distinction without a difference. No, I hate to repeat myself, but let's repeat this. The difference is voluntarily versus by force. That's a clear distinction. That's clear difference. And the very definition of inequitable conduct. Reed demands from plaintiffs precisely what she refuses to give. It's stupid. It's not a tit-for-tat situation. The doctrine of unclean hands. Oh, for fuck's sake. Bars a party from attaining equitable relief when that party's own conduct is equitable with respect to the matter in controversy. When it comes to these fuckers, I need to check. Okay. Let's see here what they actually claim. Here it is. Sorry. Let's see, what did they... There were 9:15. This is okay. This is a lien case. So the case here is not important. It is the decision of unclean hands. Dun, dun, dun. Oh, fuck. There it is. And where the plaintiff's claim was not barred by the doctrine of unclean hands, 1516. Because Wells Fargo could expect that its mortgage would remain with the property, it had no right to share in the surplus funds of McIova's foreclosure. They cited Haynes, prior mortgage and lease don't carry right in law to any excess received in foreclosure of a subsequent mortgage. Okay, 2A here. The doctrine of unclean hands denies equitable relief to one tainted with the inequitableness of bad faith related to the matter in which he seeks relief. Here it is questionable whether the trustee is seeking equitable relief. Like the cases cited by Wachovia, this is not an interpleader action requesting a declaration as to the party's right prior to the disbursement of the funds. This is an economical. This is unclean hands in an economic situation. A mortgager to bring in civil action to recover surplus funds. Unclean hands principle generally has no application to an action at law for breach of contract. But even if we were to view the claim as equitable in nature, an unclean hands defense fails. The conduct that issued Thorpe's failure to disclose his interest in the surplus in his divorce and bankruptcy cases is unconnected to Wachovia's erroneous distribution of surplus funds and did not directly affirm the claim being brought. Furthermore, there is no suggestion of any inequitable conduct on the part of the trustee or the creditors whose interest he seeks to protect. I don't think this actually applies at all. Because in this case, we have, again, voluntarily versus by force. That's the issue here. That the NDAO took the information by force and by agreement said, we will redact this. And the agreement here is regarding the Norfolk District Attorney's Office, how they keep this record. Not in different cases, how they are even allowed to keep this, to not waste the court's time and everything. So they get to keep it as long as they keep it in the redacted form. And then they sent the unredacted form to the wankers. So no, I don't think that the case they are citing applies here at all, actually. Spruce enter text. Let's quickly check that case out. False advertising and trademark dispute. That's not it. Let's see here. The page 22. Let's see here. Oh, unclean hands. This is just an annual review case. And false advertising and trademark dispute between competing radon fan manufacturers. Okay. I assume this is as far-fetched as the other one. When Karen Reed's reply is in, which it should be soon, I assume, we can actually read from her attorneys. Yeah, fuck off, you wankers. The doctrine of unclean hands precludes equitable relief when the plaintiffs have engaged in misconduct that is directly related to the merits of the controversy between the parties. There's no misconduct here. I should have just kept reading. The doctrine of unclean hands precludes equitable relief when the plaintiff has engaged in misconduct that is directly related to the merits of the controversy between the parties. Where's the misconduct? Wankers? Where's the misconduct? There's no misconduct here. Where's the misconduct? Where is your filing of Karen Read or her attorneys doing misconduct in this specific manner? Oh, you haven't filed one? Then this fucking citation is worthless. Jesus Christ. And then they quote another case: a protective order is equity relief, and read, what? For fuck's sake, this is stupid. A protective order is equitable relief, and Reed's refusal to extend the same courtesy she demands now is directly related to the subject matter of the motion. Fuck you. I mean, for fuck's sake. No. So they go emotional blackmail. They go into, well, she would do what we ask her. So, no, because it's different situation. Jen handed it over voluntarily, fully aware and knowing that it would be handed over to Karen Read. And, folks, let me remind you what case this is. Where are we? We are page 5. Plaintiffs are Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. They are the plaintiffs. They brought this action, not Karen. They brought it, and Jennifer McCabe brought it knowing that Karen Read had her phone and the contents of the phone and the extraction of the phone. You can't close a door you yourself opened, Jennifer, by filing this lawsuit. Page 5. We were at page 5. Dr. Blah, blah, blah. If Reed genuinely believes that litigants should not possess full phone extraction of opposing parties, then that principle must apply equally. Fuck you. Again, emotional blackmail. This is very, very close to a straw man argument. Very close. The court should not countenance one-sided relief that requires plaintiffs to delete data obtained by the NDAO, while Reed continues to hold the identical category of data belonging to McCabe, equally obtained from the NDAO. Are they actually listening to themselves? Who approved of this filing? This here, folks. The data belonging to McCabe equally obtained from the NDAO. Now, again, the difference is Jan McCabe handed everything over to the Commonwealth in order to prosecute Karen Read, knowing and being told that that would be handed over to Karen Read. She did that voluntarily. Nothing from Karen Read has been handed over voluntarily. Nothing. Conclusion: for the foregoing reasons, plaintiffs respectfully request that the court deny defense Reed's motion in its entirety. In alternative, hold the motion in abeyance pending resolution of Reed's motion to dismiss, given that the automatic stay of discovery is currently in effect, and in the other further alternative, condition any relief on Reed reciprocal and simultaneous deletion of any copy of the full extraction of plaintiff's Jennifer McCabe's phone that Reed currently retains. Now, here is the difficult part. They put this garbage in knowing that there will be a reply. This here is pure stalling. They know they are not supposed to have this. They just stall for time so they can have it in their possession longer. That's the only reason. Because this will take time. The reply from Karen Reed, then they might reply, wasting the court's time, and all this time they will have an unredacted version they are not supposed to have. So yeah, this here is, in my personal opinion, disagree with me if you want, or correct me if you think I'm wrong. I don't mind, as long as it is constructive criticism. Where were I? I lost my trail of thought. Oh, yeah. They are trying to make a Jen McCabe problem, because Jen McCabe thought that Karen Reed would maybe plead out, or there actually would be a conviction. So she handed over her phone to people she knew was corrupt, who knew that she could count on to manufacture evidence. Well, boo fucking who, motherfucker? Your plan failed. And now you voluntarily handed over to the Commonwealth, meaning it would be handed over to Karen Reed, came back to bite you in the ass, showing what a deceitful liar you are, Jan McCabe, in deleting messages, trying to delete phone data, deleting specific items of search history. Yeah. So yeah, there's a clear difference. An absolute clear difference. All right, folks, that was 3 motions we went through today in the Karen Reed case. There are a lot more. These were the ones I personally find interesting. And tomorrow it's Friday. And as you know, Fridays, it is the Slightly Buzzed show. There might be a special tomorrow, because as you know, I'm traveling to Indiana in 2.5-3 weeks to cover the Delphi case, the Flora 4 case, and Fosler in Hamlet, Indiana. And other people are also going to Indianapolis for the Rick Allen oral argument in the appeal. So if we can find a good time to talk, and we will apparently talk tomorrow. Okay, great. Maybe tomorrow afternoon, 5 p.m. Eastern Time, it will be a Delphi special with a bunch of very, very interesting people. But that's for tomorrow. Everybody, thank you so much. Thank you, thank you, thank you. Thank you for the 10 jewels from Old Kit, Aid Kitten, Old Kit. And thank you for $10 from Total Power. Thank you so much. From me and Mr. Jingles, hello. Thank you. You all have a good one. And I will see you back here in the next stream or video. Meanwhile, here is the Free Turtle Boy song.
Dr. Turtle Boy walks the line, truth in his hands. Fingers point at shadows, he's breaking their plans. Corrupt suits in the courthouse playing their game, but the lies they sling won't tarnish his name. They try to bury him, but he won't go down, fighting for justice in every crooked town. Dr. Turtle Boy standing tall in the fight, truth's his weapon shining through the night. Bogus charges flying, but they can't stick. He's cutting through the darkness, sharp and quick. The gavel pounds, but his voice won't break. No matter how much they take and fake, they try to bury him, but he won't go down, fighting for justice in every crooked town. Dr. Turtle Boy standing tall in the fight, truth's his weapon shining through the night. His ground in the face of their lies, his courage resounds. For every false word there's a lie he ignites, a warrior for truth under courthouse lights. He's been bruised, but he won't lose the war, kicking down the gates of corruption's door. Dr. Turtle Boy still chasing the sun. The fight's far from over, but he's never done.